Aiello versus Aiello.
Thank you.
Mr. Upton?
Thank you, Madam Chief Justice. Members of the Court, may it please the Court, my name is Jeffrey Upton from Hannafy and King, representing the appellant Joy Highland. This appeal arises from certain erroneous legal instructions given by the lower court to a receiver in connection with the receiver's equitable allocation of the assets of a dissolved corporation among the four shareholders, the four equal shareholders who were siblings. The appellant, Joy Highland, is a resident of Florida. She was not active in the management of the business.
She was on the board, wasn't she?
She was on the board, attending annual board meetings, but was not active in the, as an officer or an employee in actually managing the grocery store on a day-to-day basis. The appellees are her three brothers, Virgil, Robert, and Gerald Aiello, who did actively manage the Lucas Market, Inc.
Why couldn't, you're representing Ms. Highland, am I correct?
Yes, Your Honor.
And why couldn't she have brought a shareholder derivative suit here?
There was nothing physically preventing her from doing that. This was a close family relationship. Certainly there's always a disincentive to sue family members over money and destroy a family relationship. She was not wealthy like her brothers were from having taken the profits of the corporation over the decades. She was a widowed mother of two children working as a real estate broker in Florida and was not prepared to take on defendants who had access to the treasury of the corporation, the successful corporation, to battle with them.
But I thought the problem here is she didn't want to do that then. Now the corporation is essentially wrapping up.
The corporation is wrapping up, and now an equitable forum has been provided in the context of the receivership to allocate fairly the assets of the receivership, taking into account the competing claims of all four shareholders for a greater than pro rata share of these proceeds. And the receiver invited the parties, with the approval of the court, to submit their claims, to substantiate their claims and document their claims, and then invited the parties, again with the approval of the court, to brief for the court a number of legal issues that the receiver wanted instructions on in order to frame the parameters of the claims that the parties had submitted. The receiver wanted to know whether any of these claims, for example, were barred by the statute of limitations, whether the claims had been previously dealt with and were barred by issuer claim preclusion principles, and also the scope of the corporate opportunity doctrine as applied to certain of Ms. Highland's claims, respecting additional grocery stores that the brothers had opened as a partnership of three, excluding her from their operation, the real estate that they purchased in connection with those stores, and other investment properties that they acquired without first presenting those opportunities to the only disinterested member of the board, Ms.
Even
Highland.
if the statute of limitations shouldn't have applied, because the 75% ownership or over 50% was in the other brothers, and she had a minority share, so she couldn't have gotten the corporation to act. Why couldn't she have sued the other brothers individually?
Well, there came a point in time where she was prevented from doing so by an order of the court. When these issues were briefed for the court.
But prior to that?
Prior to that, again, why could she not have brought a derivative action?
Because it seemed to me from reading your briefs that a lot of the problems, it keeps being repeated, that she couldn't have acted because she didn't have control of the corporation. The bad guys had control of the corporation. But she could have acted against them individually, it seems to me.
Right. As a director, of course, she could not have acted for the corporation.
No, but she could have acted, she could have brought
As a shareholder, she had the legal ability to bring a derivative suit, but no obligation to bring a derivative suit.
Okay, but what about suing the brothers individually?
On personal claims for breaches of fiduciary duty?
Yes.
Yes, I think that she the statute of limitations, I don't think there is a tolling argument with respect to those claims, except for one category of claims, which was, in addition to taking excessive compensation that was reported on the books and disclosed to Ms. Hyland, she only discovered after the receiver was appointed, and her forensic accountant was given access by the receiver to the check registers and bank statements of the corporation, that over the years, as far back as the accountant looked, back to 1994, she discovered that her brothers had been taking money from the corporate operating account, writing checks to themselves, which was not recorded as officer compensation in the tax returns, not recorded as officer compensation on the books of the corporation. In effect, they were taking money under the table, which came as a surprise to her.
Again, I sound as if we're beating the dead horse, Mr. Upton, but essentially what the judge said is, look, she's on the board. If she's acting as a corporate director, she can get access to all of this. Whether she sued them individually or as a shareholder, whatever she did, now he says, I've got essentially a dead corporation, and I'm trying to allocate whatever remains of it, and this is too late. This is just too late for these claims now to be brought. These are all claims that could have been brought and should have been brought, and although she didn't choose to, and she might not have had the resources, and she wasn't in Massachusetts, those may be valid reasons, but you can't do it now.
Well, certainly with respect to the taking the money under the table, something that was not known to her, not disclosed to her, and in fact, by presenting her with books and records of the corporation that showed that no money was being taken under the table, that fact was fraudulently concealed from her. She was not aware of any facts which should have put her on notice, assuming it's a discovery standard and not an actual notice standard. She was not aware of any facts to indicate to her that her brothers were lying to her about the amount of their compensation. They told her about the excessive salaries, the excessive bonuses, and she was aware of those and objected to those, but they never told her that on top of that excessive compensation, they were stealing money from the company. So that is a category of claims that certainly stands on a different footing. And that was something that was briefed twice before the lower court, first on the briefs that were requested, and second on a motion for reconsideration, and never addressed in the order, in the interest of simply ending this family dispute, which certainly is a laudable goal, but not at the expense of parties, including the corporation's rights. I think the focus should be not so much on what Ms. Hyland knew and what Ms. Hyland could have done, but we're talking about a separate legal entity, the corporation's rights and the harm to the corporation. The rule that is applied should apply not simply to a four-member family close corporation where there may have been actual knowledge of all the directors and all the shareholders of some of the wrongdoing that was going on, but it should be a rule that applies to more broadly held corporations, a corporation where, for example, there may be a fifth shareholder out there who is unaware of what the wrongdoers were doing, because we're talking about derivative claims, not personal claims, and the injured party is the corporation. If this court adopts the majority control version of the adverse domination doctrine in this case, it should treat this corporation, this very closely held family corporation, no less favorably than it would treat a more broadly held corporation with multiple directors. This plaintiff, this corporation, should not be penalized by the fact that it is closely held by family members. If anything, her brothers owed her a heightened fiduciary duty because of the relationship of trust in the family relationship, and should not escape liability because of this close family relationship, where they would not be escaping liability were the circumstances different and the relationship more impersonal and the corporation more broadly held. Under the case law in this Commonwealth, these family members and closely held shareholders in a closely held corporation are held to a higher fiduciary duty, and along with that should be a greater responsibility and less protection from the statute of limitations. I mean, one corollary to the question I've been asked, why should she have a remedy when she sat on her rights for so long, is why should her brothers escape liability under these same circumstances?
But that applies to all statute of limitations. People escape liability because of the statute of limitations all the time.
Well, in this case, they would be escaping liability because the party who was harmed, in addition to the corporation, was their sister, who had a reluctance to commence litigation which would destroy the family relationship. Why should the fact that they owed a greater duty because of that relationship be available to them as a shield to protect them from their wrongdoing?
Yeah, but that, well, anyway, go ahead.
Mr. Upton, what is the practical effect here?
Where do we go from here?
No. If we do not agree with the judge in the Superior Court and we let her pursue her claims out with the statute of limitations being told, or in a whole, or under one of the corporate doctrines at issue, she pursues her claims, and then what happens?
I don't think that's the necessary outcome, that she then individually pursues her claims. What happened in the lower court is that the receiver, after receiving these legal instructions from the court, went and made a determination within the parameters that of the claims he was allowed to consider as to who was entitled to what share of the proceeds within his control. With respect to Ms. Hyland's claims that he was allowed to consider, some 2.5 years of claims, he awarded her $225,000 as a priority distribution in addition to her 25% interest in the whole. The facts and the wrongdoing that preceded the 2.5 years he was allowed to consider were no different, no less egregious than the 2.5 years he did consider. If the judge had correctly instructed the receiver, you may consider claims predating May 17th of 1999.
So we would basically direct the receivership to be reopened, the receiver to unwind the wrapping up, and then repackage.
That is the relief that we're requesting.
So this is not a request for the receiver and/or anybody else to go after the two brothers for further funds to be put into.
No, Your Honor. We are not requesting that this court review the business judgment or discretionary decision-making of the receiver. We're asking that this court ask the receiver to revisit the decisions he made based upon correct instructions of law as to the corporate opportunity doctrine, the actual knowledge rule, and the statute.
And specifically, what would that be? That she get a further priority distribution, or that
she get a further priority distribution. That if
in the amount of? Has there been a submission to the receiver?
No, we made a submission based on information available to us going back to 1994. The receiver made findings from mid-1999 forward. So certainly the evidence was before the receiver as presented by one of the parties going back to 1994. But the receiver had all of the books and records in his possession going back to the beginning of the corporation, which he could have examined independently.
Okay.
But the request...
And what are the assets, excluding the payment of attorney's fees, that that the receiver was distributing? What's the total of the assets?
The total of the assets was, after taxes and expenses, was just shy of $3 million, I believe. And there was the separate issue of the corporate opportunity doctrine, whether included among those assets should have been the Newbury Street building that housed the DeLuca's Back Bay, which was sold with the proceeds going to the three brothers for another $3+ million, I believe. And that is within the scope of Ms. Hyland's claims that acquiring that building in the 1970s to open a second DeLuca's market.
But I thought you just said you were not asking the receiver to pursue any of those claims. Or did I misunderstand you?
We're not asking the receiver to pursue those claims. We are asking the receiver to revisit the, well...
You're not asking the receiver to go and get...
Well, that's the question.
If the statute of limitations hasn't told, the receiver can take into consideration whether or not that asset should be properly considered with respect to distributions to her, correct?
Correct,
Okay.
Your Honor.
Is that really what you're saying?
Your Honor, the bar to requesting at the appellate level that the receiver's business judgment as to whether or not to bring derivative claims against the individuals and spend receivership assets to pursue these claims is too high for us to consider pressing that on appeal. The appeal issues are limited to the propriety of the legal instructions which the receiver was then bound to follow with respect to the scope of the claims that the receiver could consider in equitably allocating the assets that were within his control and which he had a duty to fairly distribute.
I hope I understand.
This may not be before us, but if the statute of limitations were told and/or we conclude the Superior Court judge's instructions to the receiver were inaccurate, would that bring within the scope of what the receiver could distribute to your client the sale of the property on Newbury Street?
Certainly the receiver would have the ability to revisit his decision. If he were told
To pursue that claim.
he would have the discretion to change his, after having been told by the judge.
Something he
could not.
declined already.
Right. He'd been told by the judge he couldn't. Now he would have the opportunity to revisit that decision and have the discretion to pursue it. We're not asking that he be instructed to pursue it.
Is a derivative shareholder suit is it a limited form of action in the nature of the right of a member of a closely held corporation to seek for wrongful conduct by other members of the corporation? Are they essentially the same type of action, derivative shareholder suit and a suit by a member of a closely held corporation for breach of fiduciary duty?
Well, a member of a closely held corporation would have certain personal claims for breach of fiduciary duty to the extent that the remedy would flow to the individual bringing the claim as opposed to the corporation
But is the
itself.
nature of the action essentially the same?
I think the nature of the action is determined by the remedy that is sought. And if the remedy is the bringing back into the corporation opportunities that were diverted or monies that were misappropriated, then it's a derivative claim. If the remedy is, for example, a freeze-out claim where the harm is to the individual, then it's an individual breach of fiduciary duty claim.
But Ms. Hyland essentially could have brought this same kind of action in her individual capacity as a member of that corporation. She could have sought the same kind of relief that she's seeking now as a derivative, in a derivative shareholder suit.
No, Your Honor, I don't think she could have brought a direct claim against her brothers for excessive compensation. Sure. Because of the nature of the remedy that was sought, it would have to be a derivative claim.
Yes, because the harm was to the corporation.
Precisely.
Thank you, Mr. Upton.
Thank you, Your Honor.
Mr. Needham?
May it please the Court, I'm Paul Needham. I represent Robert Aiello, and with me on the brief is Mr. Mark Johnson. This case comes before the Court in a rather unusual posture, and that's simply because, as the appellant has said on page 12 of their brief, and I'm just going to read the 2 lines, this appeal does not challenge the facts as found by the receiver or the lower court. Rather, it assumes the correctness of the receiver's findings of facts such as they are. So we have dense finding of facts. We don't have to spend any time at all deciding whether there's evidence to support them. And one thing that was stated in the opening by my brother is that Joy could not maintain these suits, that Joy is not a wealthy woman, that she's impoverished. Nothing could be further from the truth. She has a very lavish lifestyle in Florida, and there's a specific finding in the record.
That's kind of irrelevant, isn't it?
Well,
I mean, if the statute is operative, it's operative against people who can afford to bring the suit or not afford to bring the suit. You know, or
I'm
whether
addressing
the family relationship is involved or not. It's the question is, if you got a suit, you got to bring it.
Absolutely. I'm just bringing up what was found in the record at A44, where there's a specific finding that she had the means to bring suits and did bring suits.
It doesn't make any difference.
I agree it doesn't make any difference, Your Honor. It doesn't make any difference at all. But let's look at what the facts found.
Could she have brought this suit as a member of that corporation?
Absolutely. She could have brought a breach of fiduciary duty suit. There was a
But
suit.
the harm was to the corporation.
She
Excessive compensation, the harm is to the corporation. She can't take, let's assume that your client was paid $1 million too much, excessive compensation, he took $2 million under the table, whatever. She can't get access to that. That's harm to the corporation.
She can bring, in fact, the suit that Gerald bought in 1998, in which Joy was initially a defendant, alleged all the wrongdoing back to 1971. It was a breach of fiduciary duty suit, and it asked for relief that the money be paid back to the corporation.
That's a shareholder derivative suit, isn't it?
Well, the shareholder derivative suit is bought in the name of the corporation to refund to the corporation money that was taken.
Well, she could have done that.
She clearly could have done this. She had knowledge from as far back as 1994 of absolutely everything. And the record...
Did she have knowledge of what she alleges to be the fraudulent taking of money, not as compensation, but, I mean...
It says in the record, first of all, there is absolutely nothing in the record anyplace that anything new was discovered in 2000, in 2002 when she got another accountant. Because in 1995 she had an accountant, and the record says very clearly at page 42 and 44, that accountant got tax returns back to 1968, that accountant got documents, that accountant got everything that everybody was paid, that she at the time made claims about corporate opportunities.
So what you're saying is there was no fraudulent concealment.
There's no
All the
evidence.
information that was needed to bring the suit was available to her or her accountants.
Absolutely, and the very dense factual findings by the receiver, and they were all adopted by the trial court, found that she had detailed knowledge of exactly what was being taken out of the corporation. She had detailed knowledge about the building at Back Bay, and that she specifically in writing made complaints about those exact issues, and that at a board of directors meeting in 1996, this is in the record on page 35, that it was all brought up. It was all discussed. And then in
Mr. Brown, is it...
Mr. Needham, Your Honor.
I'm sorry, Mr. Needham. Is your theory a kind of waiver theory?
Well, our theory is, I suppose it's waiver, but what we're really saying is she had actual knowledge of all the problems.
Yeah, so is you saying she had enough knowledge, as you have in a typical discovery issue, for purposes of knowing you've got a right to bring a lawsuit, and at that point the statute starts running. That's what you're saying.
That's exactly right. And she had
it's
it.
sort of related to waiver because if you don't bring it.
She had it as early as 1994, very, very specifically. And in addition to that, there was a suit raising all these same issues brought by Gerald in 1998. Joy was a named defendant. She never counterclaimed. She never cross-claimed. And this is all in the record. That encompassed all the wrongdoing.
So she was served with all the papers in that case.
Yes.
And knew everything that was said in the papers,
Yes.
the pleadings. And did she file an answer?
She filed an answer, and she subsequently was dismissed from the case by her brother Gerald without filing any counterclaims or any cross-claims. Again, in the year 2000, when Robert and Virgil filed a shareholder derivative suit, she was a defendant, and she counterclaimed. And she counterclaimed for everything that she says she wanted the receiver to do as she wants to do now. She counterclaimed in that case, and that was the 02913 case in the business litigation session. She counterclaimed for corporate opportunities. She counterclaimed for excessive compensation. And then she voluntarily dismissed that at the end of November in 2001. So in addition to having knowledge, specific knowledge of all the details as early as 1994, there were two opportunities in court, one in 1998 and another one in 2000-2001.
Did the Superior Court judge throw this out on statute of limitations as to the derivative shareholder suit because even as a derivative shareholder suit it was untimely, or was it dismissed because she could have brought this in her individual capacity for breach of fiduciary duty?
He appears to have thrown it out because of the fact that under whatever theory you used, she had actual knowledge of the specific details.
The problem that I have with that, though, Mr. Needham, is the following. She's a minority shareholder.
Correct.
The relief, even if you call it a breach of fiduciary, but I'm asking for the money to go back to the corporation, that's a shareholder derivative suit. Shareholder derivative suits, not just anybody can bring a shareholder derivative suit. And so when you have an ongoing corporate, the question is to what extent, as a practical and or legal matter, was she barred? Not because she didn't have knowledge, but that essentially it was an ongoing corporation where the claims are essentially shareholder derivative actions, and she's not in a position legally to accomplish a shareholder derivative action because of her minority status. She's now in receivership, and she says, now I don't have that problem. These are legitimate claims for the wrongdoing that certain members of the board inflicted on the corporation?
Well, in the year 2000, she was sued in a shareholder derivative suit where her brothers were making claims about violations by Joy and by Gerald, and at that time, she easily could have counterclaimed because there was a shareholder derivative suit. Corporation was named as a defendant, and she did counterclaim in that, and she subsequently dropped it. So she had substantial opportunities.
The purported, and I'm not suggesting that there has been wrongdoing, I'm just assuming that there has been wrongdoing for purposes of understanding the legal argument. The wrongdoers are bringing the shareholders' derivative suit, correct? In the 2001 action, when she's named as a defendant.
She's named as a defendant, and the allegation was that, in fact, she was the wrongdoer and Gerald was the
No,
wrongdoer.
I understand that. So what are her counterclaims? Her counterclaims are individual counterclaims.
I believe the counterclaims were that there was a breach of fiduciary duty to the corporation.
That's what I call individual. Those belong to her.
And clearly, at that time, she could have raised the issue because
Of what?
She and her brother at that time, the corporation was deadlocked at that time. That's why it was dissolved.
Right.
So nobody was in a position to control the corporation. In fact, Joy and Gerald controlled the building where the corporation was maintained, and that's what caused most of the problems. But it was deadlocked at the time, but she counterclaimed, and you need to look at the factual record. And to wrap up, what I'm just going to say briefly is there's been no objection. All the facts are assumed as found. They're very dense. They're very factual. And especially between pages 32 and 35 and 42 and 46, there are dense factual findings about what Joy knew and about the fact that she had actual knowledge. And at this point, Your Honor, I think it would be entirely inappropriate to attempt to open this up to seek relief, which Joy has declined to seek when she had numerous prior opportunities in various capacities to bring.
Was she a defendant in that other derivative action?
Yes.
Under an allegation of wrongdoing, or was she added as a necessary party?
There was an allegation of wrongdoing because when the owner of the building died, Joseph DeLuca, everything was 25% each. He left 3/7 to Gerald, 2/7 to Joy. So they had control of the building. So they immediately dramatically increased the rent on DeLuca's, the corporation, and that was one of the bases to say that she had breached her fiduciary duty by using her position as trustee to cause the corporation to have to pay exorbitant rent.
Thank you, Mr. Newman.
Thank you.
Mr. Brown?
Good morning, Your Honors. I wanted to amplify a point that was just discussed. It was a 2000 action, not a 2001 action.
Okay.
And specifically, and I'm sorry it's not in the appendix, the counterclaim that was filed on behalf, Joy filed her own counterclaim. It was a shareholder derivative action alleging the very same abuses that are the subject of this appeal, the very same claims that were brought to the receiver, excessive compensation, et cetera. So I don't think this has been said by anybody, but I will represent to the Court that that is in fact true. I was not counsel at that time.
So it was not a breach of fiduciary duty. It was not an individual.
There were claims asserted. Sometimes it's not clear when you bring these claims whether they're individual or derivative.
Correct.
And in that counterclaim, it was she asserted both derivative and individual.
Can you help me out a little bit?
Yes.
Does this intersect at all with some stuff that we said in the Demoulas decisions? The Demoulas decision recognized that there were two tests that might have some bearing on a statute of limitations question. One is the adverse domination test, and the other is the disinterested majority test.
Yes.
And then I think it's claimed here that the limitation periods doesn't run until disinterested and independent directors are in a position to act on behalf of the corporation. And it's claimed that that's the test that Demoulas adopted. Is that so? That's my first question. And second, if it is so, is that test met here?
To answer Your Honor's question, that's not – I don't believe that's what Demoulas says. Demoulas – the holding in Demoulas is not – first of all, it doesn't specifically adopt adverse domination. It says that our decision is supported by adverse domination, but Demoulas is based on the repudiation of trust and fraudulent concealment doctrines.
The thing I just read to you, which is a quote from Demoulas. Quote, the limitations period should not run until disinterested and independent directors are in a position to act on the corporation's behalf against corporate wrongdoers.
Right.
Page 522.
And, Your Honor, if I could continue from that same sentence,
Okay.
I believe, following, it says this, and this is what I believe is controlling here.
All right.
When a corporation is the injured party in a shareholder derivative action, the repudiation of trust and fraudulent concealment doctrines prevent the statute of limitations from running until knowledge is gained by those who have the power and responsibility to act on the corporation's behalf and who are not themselves involved in the wrongdoing.
Well, that's the disinterested and independent directors, and we don't have any of them here.
Well, we do have at least one.
What you're saying is she knows
Absolutely.
she knows at the time.
Yes.
And you can establish that from the record because in her counterclaim, by whatever nomenclature you categorize it, she was alleging excessive compensation, stripping of the assets of the corporation, whatever else.
And we also have these very intricate, detailed findings by the receiver as to what she knew and when she knew it.
Okay.
And what I'm suggesting to this Court is that this case can be decided perfectly consistently with Demoulas simply by saying that in this situation, in a shareholder derivative claim, when you have the shareholder bringing the claim fully knowledgeable and with no impediment to bringing the claim, she could have brought the claim. In that situation, the statute is not told. She's the person with the knowledge. She's the person with the power to bring the claim.
I assume you addressed in your brief this little Demoulas intricacy.
Absolutely.
All right.
I do cover that.
But we certainly don't want to change anything in that case.
Well, I don't think there's a need to. I don't think there's a need to change it.
For obvious reasons.
But I would say that this can be decided perfectly consistently and just built from what it says in Demoulas. She's the person with the knowledge. She's the person with the power. And to answer Justice Cowan's question, there was a question, couldn't she have brought this claim earlier? Yes, she could have. And, in fact, she did. And that's, that the proof that she could have brought it is that she did bring it in that 2000 action, which was later transferred into Suffolk and became a 2001 action. I would like to take
What was the resolution of that, of her counterclaim?
She withdrew it. She dismissed it without prejudice. So it's not dispositive in a res judicata sense, but what it does show is that she knew about it and she had the ability to bring it and she brought it. There was no reason. She knew about all these things and she sat on her rights.
Well, she knew about it. She knew about it in 2000.
Yes.
But the judge ruled that the statute goes back to 1999, right?
Yes.
So if she knew about it, if she gained knowledge of it between May of 1999 and the time she filed her counterclaim, why isn't the statute? Why does the statute apply to that? That would be told if she actually didn't have knowledge of it, right?
Well, except for the fact that the receiver also, I'm just mentioning this as an example of what she had the power to do, but the receiver's findings show that she knew about all of these things.
Even before 1999.
1994, 1995, and she didn't do anything.
When did she get and her accountants get access to the corporate checkbook?
1994, 1995 time frame, and this is all covered in the receiver's report in great detail, and it's at pages A32, A33, and A42 and A43.
Let's take a break.
Judge Van Gestel, I think, made an important point. When he wrote his opinion, December 2002 opinion, stating, rejecting Joy's argument, what he said is, if you follow her argument to its logical extension, there would never be a statute of limitations for a shareholder derivative claim in a, quote, demand-excused situation, which is what this is. A shareholder can bring the claim if it would be futile to make demand on the board, and that's what I guess she would say here. And Judge Van Gestel pointed out, and rightly so, that under her theory, there's no statute of limitations. You can back 20 years. You can know all about something. And this is, what is the case here? Know all about something, sit on your rights, do nothing, and the statute tolls it. And that would set a terrible precedent. I think the message that you would send by adopting, Ms. Hyland's viewpoint is that there essentially is no statute of limitations in a shareholder derivative action. You can know all about something, but as long as you're in the minority and there's not a, quote, disinterested majority, there is no statute of limitations. It's a classic open the floodgates of litigation situation. I wanted to address just very briefly, I think there are some procedural impediments in this case that I've briefed.
Yes.
And I just wanted to address them very briefly. First is, the notice of appeal does not – what Ms. Hyland is saying is the judge incorrectly and the receiver incorrectly apportioned the assets, didn't give me enough. But the decisions in which the apportionment was done are not mentioned in the notice of appeal, and I think that's contrary to Appellate Rule 3C. And it's not a technicality because there's a related argument, and that is this. She took the benefit. She got
I thought it was a general notice of appeal.
Sorry?
I thought the notice of appeal was a general notice of appeal.
The notice of appeal says she's appealing from, and it's in my supplemental
Yeah,
appendix.
no, I saw that.
She's appealing from the judgment dismissing, which ended the case, and she's appealing from these two decisions in December of '02 on statute of limitations grounds. But what happened after that was the receiver actually went ahead and allocated the assets, gave her an extra $350,000. She didn't complain about that. She didn't protest. She didn't object. She took the money. And there were a series of decisions by the receiver and approved by the court allocating money to her, giving her money, and then in October 2003, a decision granting permission to immediately distribute the assets. She didn't object to that. So
well, I mean, and we will look at it, Mr. Brown, but it seems to me that if the receiver is proceeding under, as it were, chess rules, and she says, I don't think chess rules should apply, checker rules should apply, checker rules will give me more than chess rules apply. I'm taking the chess rules, but I still want to go back and get the checker.
Well, even if that's the case, she ought to have in her notice of appeal specified. That's what Rule 3C is for. Okay. I want to, if I could just, if you would indulge me with one other point. There's been a lot said about these are harm to the corporation claims. I cover this in my brief. These claims belong to the corporation. They became the property of the receiver. The receiver deliberately chose not to bring the claims. And this had nothing to do with the statute of limitations. It was before the judge's ruling on statute of limitations. He chose not to bring them. Judge Van Gestel said, effectively, you know what you're doing, Mr. Receiver. You're there. I'm not going to make you bring the claims. And I would say to this Court that when that happened, these claims died. She no longer had a right to bring any derivative claims. These were corporate property, became the property of the receiver, who chose not to exercise them. That was the end of these claims. So when we talk about what might happen on remand, she has no right to bring these claims. Their existence has terminated through the deliberate decision of the receivership, of the receiver, that was not appealed by her. So I would say that even,
Is this all this in your brief?
It is covered in my brief. There's about half the brief is devoted to procedural issues and about half to statute of limitations. And I think the procedural issues really bear some – this is a very peculiar case in terms of its posture and the procedure below. And it really bears some scrutiny, and these procedural issues, I think, are important. So I thank Your Honors, and I appreciate the indulgence.
Thank you, Mr. Brown. We'll take a short break.
All right.